The key terms in dealing with your children in your separation or divorce are the terms custody and access. I will deal with the issue of access in another video. In dealing with the issue of custody, you often hear the terms sole custody and joint custody. Whether the issue of custody is dealt with in court or is settled before court in a separation agreement or a settlement, you generally have either sole custody or joint custody of your children. Hi, my name is Thomas O'Malley. I'm an experienced family lawyer in Durham Region. Sole custody can be defined in the following way. To award one parent the exclusive custody of a child is to clothe that parent for whatever period of time he or she is awarded custody with full parental control over and ultimate responsibility for the care, upbringing, and education of the child, generally to the exclusion of the right of the other parent to interfere in decisions that are made in exercising that control or in carrying out that responsibility. Sole custody gives you the right, in other words, to make all the decisions respecting your children. This includes all decisions about health, education, and welfare of your children. Joint custody, on the other hand, means that both parents have joint decision-making responsibility for their children. Both parents have an equal right to be involved in all decisions respecting the children, including decisions about the children's school, where the children live, health and medical decisions, and sports activities in which the children are involved. Even if you have joint custody of your children, it must still be decided where the children will live on a regular basis. Often a joint custody order also states that the primary residence of the children is awarded to one particular parent. Joint custody does not necessarily mean that the children live with each parent for half the time, though that is becoming more common in Ontario. Joint custody only means equal decision-making powers about the important issues in the lives of the children. Parents can agree that the children spend half the time with one parent and the other half of the time with the other parent. However, joint custody only refers to equal decision-making powers about the important issues in your children's lives. When will a parent not get joint custody of their children? There is a big issue about whether a court will order joint custody of the children. The court will look at whether each parent accepts that the other parent is a fit parent to have custody of the children. The other factor that the court will examine is whether each parent can cooperate with the other parent. Joint custody is only appropriate where the parents are able to cooperate and communicate effectively in the best interests of the children. Courts have generally been reluctant to order joint custody where parents are unwilling to set aside their differences and work together to raise their children. The Ontario Court of Appeal, in a recent case, gave considerable guidance about the issue of joint custody of children. In this particular case, the husband and wife were only married for 2.5 years. It was a really difficult and violent marriage. They only had one child who was only 3 months old when the husband and wife separated. The father left the matrimonial home after he was charged with uttering a death threat to the mother. The father never returned to the matrimonial home, and attempts at counseling were unsuccessful. The father sought a form of joint parenting known as parallel parenting. Parallel parenting means that the parents have equal status and exercise the rights and responsibilities associated with custody independently of the other parent. The mother opposed the father's request for joint custody of the child. She argued that the parties could not communicate without screaming at each other. She led evidence at the trial about the uncontrollable foul language exchanged between the parties at the marriage counselor's office. She introduced evidence about a screaming incident that was witnessed by a neighbor when the husband came to pick up the child at the home of the wife's parents, where the wife had returned to live. The trial judge had ordered joint custody of the child. She stressed that the wife had acknowledged that the husband was a good father to the child. The Ontario Court of Appeal set aside the trial judge's order for joint custody. The Court of Appeal stressed that there must be evidence that the parents can communicate with each other about all aspects of the child's life and well-being. The Ontario Court of Appeal explained that a husband and wife should not be ordered to have joint custody on the basis of the belief that they can get along at some point in the future. There must be a real-world evidence that the husband and wife have been able to cooperate and communicate effectively, previously and currently, to justify joint custody. There is no such evidence in this case. As a result of this lack of evidence, and no evidence of a parenting plan from the husband, the Ontario Court of Appeal awarded sole custody of the child to the mother. The Ontario Court of Appeal clearly stated the fact that one parent professes an inability to communicate with the other parent does not, in and of itself, mean that a joint custody order cannot be considered. On the other hand, hoping that communication between the parties will improve once the litigation is over does not provide a sufficient basis for the making of a joint custody order. There must be some evidence before the court that despite their differences, the parents are able to communicate effectively with one another. No matter how detailed the custody order is made, gaps will inevitably occur, unexpected situations arise, and the changing developmental needs of a child must be addressed on an ongoing basis. When as here, the child is so young that she can hardly communicate her developmental needs, communication is even more important. In this case, there was no evidence of effective communication. The evidence was to the contrary, in fact. The bottom line is that a husband or wife must have solid evidence that the parents have been able to get along in the past and today to get a joint custody order. The Ontario Court of Appeal also pointed out that the husband should have provided evidence about a practical plan for the child that he proposed to make when he had the child and the benefits to the child of such evidence. Make sure you spend some time with your family lawyer discussing this important issue in your separation or divorce. If you have any questions about your separation, divorce, or family law case, and you would like our help, there's a few ways to contact our office. You can leave a message on my Facebook Law Office page, visit my website at www.canadiandivorcelegaladvice.com, or call me directly at 905-434-8837. We would be happy to speak to you. Oh, by the way, did you know you can protect your family law rights and get essential information on settling your family law issues with your former spouse with the daily indispensable family law advice and tips at my free Facebook group? Go to Facebook and search Durham Region Separation Divorce Legal Support Group in the top search bar. You'll find the group and join. Thank you for watching this video, and have a fantastic day.